My name is George Parnham. Um, I have been practicing criminal defense law for 51 years, over half a century. During the course of my representation of individuals, I have been involved in a representation of those that have been accused of sex offenses. And I think it's important to recall and remember that so many of these cases are tried only because an individual who is charged with this particular offense, if that individual acknowledges guilt, that will follow that person for the rest of his or her life. And it can have absolute ruinous consequences on careers, family life, things of that nature. So I find myself in many occasions defending individuals in front of juries and judges based on the fact allegation. And that's basically the reason for doing that. I have done this for over half a century. I have thoroughly enjoyed what I'm doing and hope to be able to do it for a number more years. With that being said, I'd like to take this opportunity to introduce my associate, Tom Abbate. Mr. Abbate has been with me for a number of years. He is an excellent lawyer and will brief you all on the legal aspect of this type of allegation.
Tom Abbate with Parnham & Associates. Today I'm going to be talking to you about defending sex crimes. And we've got other videos that cover the ins and outs of different sex crimes. So today my discussion is just going to be limited to what you need to be looking for in choosing an attorney to represent you if you're charged with these kinds of crimes. Now, the big one to remember is that in most sex cases, there is unlikely to be a lot of physical or forensic evidence. Most of these crimes are crimes against children. They may have searched for or conducted a rape kit, searched for physical and forensic evidence, but a lot of times due to a delay in the outcry, you're not actually going to find those things. And so what that boils down to is that most of what the jury is going to hear and make their decision upon is going to be the testimony of the witnesses involved. Now, in Texas, a charge can be legally sufficient based on the testimony of one witness if that testimony meets all of the elements of the crime charged and the jury believes that witness beyond a reasonable doubt. So this becomes very important from a defensive standpoint because one of the main issues that you're going to have to deal with in most of these cases is going to be the credibility of the complainant and possibly the credibility of anyone that she told that story to. Because under the Texas Outcry Statute, the first person 18 years of age or older that the offense was relayed to is allowed to testify to help shore up the child witness who maybe due to their age and inexperience is going to have some difficulties testifying in a court of law. So what you need to be looking for in terms of choosing your attorney is what do they have in terms of resources available to them. One of the things that we always do in our sex cases is we get our experts to go review the CAC video, and look for any kind of cues in that video, psychological, physical, anything that they give off that might indicate that this child has been coached and told what to say. This is very labor intensive. We have very good doctors that assist us with this And they will review the case from that standpoint, compile a report, and tell us what issues there are on credibility. This can be done by looking at the CAC video, any therapy records that you can get a hold of, if the child went to any kind of therapy, any school records, things like that. Sometimes, looking at a case, you find out, well, the child was actually doing really bad in school, and they're getting into a lot of trouble, and all of a sudden this allegation comes out. And the question then becomes, is it an allegation designed to shield the child from any repercussions for their own actions, or is there something really here? And that's what you need these experts to do, all of this review, and to be able to assist the attorney in cross-examining that complainant. The other thing when you're dealing with credibility is you need someone who's experienced in these matters, because cross-examining a child witness or any person really that has a claim of sexual assault is a very, very delicate matter. You don't want to make the jury angry based on the questions that you're asking. So while you have to be firm with that witness, you also need to appear to be, kind and considerate of that witness in a way that you might not necessarily have to deal with other witnesses and other complainants. So it's very important that you hire someone who has experience in this kind of an area if you've been charged with this kind of crime. Now, the second issue that you've got to be aware of is how are the negotiations structured. A lot of times with the vast majority of these cases, they are going to be tried. The state may make an offer, but any kind of sex crime is typically going to have registration requirements that come after. So while the DA may be offering you 5 years deferred, that's not necessarily as good as it looks on the front end, because after that probation is complete, that defendant is going to have to register for either 10 years or possibly even the remainder of their life on the sex offender registry. And that will carry and follow through with them every time they apply for a job. It's going to come up. There are additional criminal penalties that they can be subjected to if they fail to register in the correct and timely manner. And so it's very important that during any plea negotiations, not only is your attorney trying to get the charge resolved in such a way to either get rid of or limit those issues as much as possible, but also making sure that the DA stays in touch with their complainant. One of the things that occurs over the course of these trials is that, once the charges come down, it may be a year or more before you actually get to trial. And during that time, the DA's office, obviously they have other cases. Sometimes they don't keep in touch with their complainant. And this can be important to kind of, as you're negotiating with the state, pick out instances, things that you need clarification on, so that the DA is constantly going back to the complainant as much as you can possibly make them. This can be helpful from a defensive standpoint, because at some point, this complainant, if they are in fact lying, will probably slip up and or admit to the lie. This is very helpful because then this can result in a dismissal of the charges or a reduction of the charges. Both of which can be, very helpful to the defendant, because a dismissal, obviously they're not getting convicted of this because the DA's figured out that they've been sold a line of horse manure. But on top of that, if you can get the charges reduced to something that doesn't require registration, that is definitely something that the defendant should consider before deciding whether or not to go to trial. Because if they go to trial and they lose, they'll have to register. But if you work out a plea deal where they don't have to register, maybe it's worth it to them. Now, the third thing that you've got to look for in an attorney is someone who is experienced with appellate law. And the reason I say that is that these cases always have issues. Most of the time, like I said, it's being testified to through the Outcry Statute. In order to have that occur, the court is required to conduct some informal hearings on the record to make some determinations about whether or not this outcry can come in. And, if it's not done correctly, then it could potentially, the conviction could be overturned on appeal. Now, the reason I say you need someone experienced in appellate law is because you need an attorney that knows when to object and how to object. You cannot raise anything different at the appellate court that you did not raise at the trial court, so it's very important that whenever an attorney is objecting, that they preserve the error correctly. If they object on one basis, but the real answer was a different basis, you can't then go to the appellate court and argue that other basis. You have to have addressed it to the trial court at the time. And this is why you need someone who's experienced in appellate law, because they will be more familiar with those phrases. They will know what to say, when to say it. And they are very, very focused on preserving a record, because if the trial court makes a mistake, the trial is going to continue on and a conviction may come down. That can be dealt with on appeal if it was properly preserved. So it's very important that you hire someone who has some experience in appellate or post-conviction law.